3, 2, 1, start. Aggrieved by the decision delivered by learned single judge dismissing writ petition regarding maintainability of the arbitration proceedings, Union of India preferred writ appeal and the division bench dismissed the same. The main contention advanced by Union of India before the division bench was that the claimants had received compensation amounting to rupees 18,98,000 under the agreement in Form K, and therefore there did not exist any dispute as to the amount of compensation payable for the same to the owners, for which an arbitration was required to be entered into in exercise of the power under Section 8 within bracket 1 of the 1952 Act. This argument was rejected by the division bench, holding that there was no material on record to show that the claimants had communicated their acceptance to the offer made by Union of India. On the contrary, the division bench found that when Form K came to be executed, the amount of rupees 14,80,000 was accepted by the claimants under protest. The division bench further found that Union of India has never denied receipt of objections from the claimants at the time of receiving compensation. In the circumstances, the division bench found that there existed disputes between the claimants and Union of India regarding the quantum of compensation, and therefore it was not open to Union of India to challenge the notification issued under Section 8 within bracket 1 of the 1952 Act appointing the arbitrator. The division bench agreed with the view expressed by learned single judge that Form K contained clause 6, which itself stipulated that any dispute or difference in the matter of determination of compensation shall be decided by arbitration. It was observed that in the present case, Union of India made an offer of rupees 18,98,000 under the agreement dated 18/7/75, when the premises were under requisition, and by such an agreement no right, title, or interest was ever transferred by the claimants to Union of India. Therefore, it was held that the notification under Section 8 within bracket 1 of the 1952 Act was valid. This was the main aspect to be decided by the division bench. However, when the writ appeal came for decision, the award for the arbitrator had come into existence, and therefore the division bench observed that the question of the validity of the award, whether by consent or otherwise, was not required to be gone into, because the only question before the division bench was whether the notification issued under Section 8 within bracket 1 of the 1952 Act was with or without jurisdiction. The High Court therefore did not go into the question of the merits of the award. The High Court declared that the notification under Section 8 within bracket 1 of the 1952 Act was valid in law, as there existed a dispute as to compensation between the claimants and Union of India. Union of India thereafter preferred an application for review before a division bench of the High Court against the judgment delivered by the earlier division bench of the High Court. This appeal is directed against the final judgment and order dated 18/8/2003 in letters patent appeal number 1085 of 2002 filed by the appellant herein. By its impugned final judgment, the High Court dismissed the LPA filed by the appellant herein. Brief facts are that the appellant joined the service in 1953 as an overseer. The appellant was regularly submitting his property return showing all his movable and immovable properties. As per the department, the movable and immovable properties were disproportionate to his known sources of income. The Anti-Corruption Bureau carried out an investigation against the appellant and submitted a report, and on the basis of the said report, a charge sheet dated 1979 was issued alleging that the appellant had illegally accumulated the excess income by way of gratification. The appellant submitted his explanation on 15/5/1979 and denied the allegations as well as charges made in the charge sheet. A departmental inquiry was ordered, and as per departmental inquiry reported dated 31/3/1980, the appellant was found guilty of the charge. The respondent, by order dated 21/10/1982, passed an order of dismissal from the service as punishment. Against the said dismissal order, the appellant filed a writ petition before the High Court. The learned single judge concluded that there is sufficient evidence against the appellant and dismissed the petition. Against the order of the learned single judge, the appellant preferred LPA and raised the relevant contentions. The division bench dismissed the LPA by confirming the order of the learned single judge. The said decision is challenged in this appeal by special leave. Mr. Nageshwar Rao, learned senior counsel appearing for the appellant, submitted that the appellant, being a government servant, submitted his yearly property return regarding his movable and immovable properties. The return for the year 1975 was verified by the department, and being of the view that the appellant had movable and immovable properties worth more than known sources of his income, and being dissatisfied with the explanation of the appellant, the government requested the Director of Anti-Corruption Bureau to inquire into the matter vide its letter dated 11/1/1977, and on the basis of the report of the investigating officer, the department had issued a charge sheet upon the appellant. On the same material, criminal proceedings were also initiated under Section 5(1) of the PC Act. On the same basis of the same charges and the same evidence, the department passed the order of dismissal on 21/10/1982, whereas the criminal court honorably acquitted the appellant vide its order dated 30/1/2002. Mr. Rajkumar, learned counsel appearing for the state, submitted that upon the investigation, it was found that the total income of the appellant out of the salary, interest, rent, etc., could not be sufficient to acquire the property owned by the appellant, and that the total value of the movable and immovable and other properties acquired by the appellant had been found more than the known source of income by the appellant.